This Honorable Court of Criminal Appeals is now back in session. Please be seated.
All right, would you call the next case, please?
Lavino Horne versus State of Tennessee.
All right, counsel.
Good morning again, Your Honors. Welcome to Mr. Kirby May, and may it please the court. I am again Josie Holland, representing Mr. Lavino Horne, also by appointment. This is a case about counsel's total abdication of his role and responsibilities to his client. First, we're going to address the due process tolling issue because the court appropriately decided that the statute of limitations for the time to file the petition for post-conviction relief should have been tolled. And second, we're going to argue that the trial court erred when it denied Mr. Horne's request for post-conviction relief because of trial counsel's abandonment of his client, for trial counsel's failure to follow through on his motion for severance, as well as trial counsel's failure of investigation. I would like to reserve 4 minutes for rebuttal, please.
All right, 4 minutes.
The right to counsel attaches once the state initiates its prosecution. State versus Mitchell, quoting Kirby versus Illinois, that is when the prosecutorial forces of an organized society are put upon a defendant. So in this case, Mr. Horne, after not hearing much from his attorney, his appointed attorney for an extended period of time, was summoned on the weekend of Good Friday to the homicide office. He was put in a room next to one of his co-defendants, Mr. Stubbs, and he made a statement to Mr. Stubbs and was subsequently questioned by the police and the district attorneys therein. The trial counsel, he said that he trusted the district attorney who was on the case and that he didn't see any problem with allowing Mr. Horne, who was indicted as a juvenile, to meet with the prosecutor as well as the police officers involved in the case. This was meant to be a proffer session prior to trial, and it was a watershed moment for the case. Up to that point, Mr. Horne was planning on testifying at least Mr. Horne's counsel was planning on Mr. Horne testifying at trial and receiving consideration or receiving a reduced sentence from the state for that reason. But because trial counsel failed to meet with his client, because he failed to understand his client, and because he failed to ask his client's opinion about that, Mr. Horne had decided that he was not going to testify. It did prejudice Mr. Horne, and United States versus Chronic offers that the right to counsel should be inviolate, that this is an adversarial process, and by abdicating his role as Mr. Horne's counsel, trial counsel effectively left Mr. Horne without his Sixth Amendment rights.
So now, the interview didn't take place, though, right? Or it did?
So there was some conflicting testimony. The officer was a little fuzzy in his memory, and Mr. Ray Lapone was not actually called. That was the district attorney who was said to have spoken with Mr. Horne. But Mr. Horne testified that he did have a brief discussion with the prosecutor as well as the officer involved in the case. So there was.
Was there discussion or testimony about the fact that the petitioner and his co-defendant were kind of talking about what they were going to say? Or did I misunderstand that?
That was the testimony. No, that was absolutely what went on. Mr. Stubbs.
And as a result, the prosecutor didn't talk to him, but you're think it's otherwise?
Yes, Your Honor, there was testimony that it was otherwise, that Mr. Lapone and the lead investigator on the case did speak with Mr. Horne briefly. Now, those statements were not made subject at trial, what he said to Mr. Horne or the district attorney. But the fact was he was left in a room unaccompanied by anyone when he made those statements to Mr. Stubbs. Now, I suppose the question is what would have changed had counsel been there? Or had counsel said, listen, it's Good Friday weekend, I'm going out of town, don't talk to my client. Well, Mr. Horne never would have made a statement to Mr. Stubbs. Mr. Horne would not have been in that room capable of making any statements to Mr. Stubbs. And the statements that Mr. Horne made aren't particularly incriminating. He simply expresses that he does not wish to speak with the district attorney or with the police officer. Now, had Mr. Messler been there, trial counsel been there, perhaps he could have acted as a diplomat. He could have smoothed over the situation between Mr. Horne and his reluctance to testify, but we will never know that because counsel simply abandoned his role. He simply abandoned his duty to his client to be there at a critical moment for the case. Mr. Horne has a life sentence and struggles with reading and writing. It's hard to say that if Mr. Messler had been there for his client, certainly the outcome of the case would have been different.
I believe the post-conviction court found that to be prejudicial or to be deficient performance, but that it was not prejudicial.
That is correct, Your
What are you
Honor.
arguing is the prejudice that was proven at the post-conviction, not speculation?
The prejudice, Your Honor, is that Mr. Horne was left without counsel. That in itself is prejudicial. That in itself violates one's due process rights. This is not a collaborative system between the prosecution and the defense. The defense's role is to be adversarial, is to actually have distrust in the other side. What Your Honor might call speculation, it seems that the appellant would put forward, it was proven by clear and convincing evidence that Mr. Horne would not have been in that room and Mr. Horne would not have made those statements to Mr. Stubbs had counsel said, don't take my client to the homicide offices to interview him. That's certainly what would have occurred. And I don't know that that has to be something that was explicitly stated during the post-conviction hearing, but as people of common sense, we would know that if counsel had said, don't take my client to the homicide offices to speak with him, that Mr. Horne would not have been there and would not have made any sort of incriminating statement to his co-defendant.
And what was incriminating? I thought he said he just wasn't going to talk, didn't want to testify, that type of thing.
The incriminating part was what Mr. Stubbs said to him. He said, we need to tell these people the truth about what happened. And Mr. Horne says, no cuz, no way. Now, does that mean Mr. Horne was never going to tell these people the truth, or does that mean Mr. Horne was scared to testify against these individuals who were accused of murder? We don't know.
Of course, didn't Mr. Horne, didn't his lawyer say that Mr. Horne had said that he was the shooter to him?
That was what trial counsel said.
Yeah.
But at the post-conviction hearing, there was an alibi.
Trial counsel testified to that at the post-conviction hearing.
The trial counsel testified to that at post-conviction hearing. Of course, one might doubt that that was what Mr. Horne said to trial counsel, because trial counsel is making an effort to say that he was not ineffective, and the trial court didn't.
Trial counsel was under oath.
Trial counsel was under oath, and Mr. Horne was under oath.
Well, yeah, but are you suggesting somebody would lie under oath that is in a position of losing their license to practice law?
think that to protect one's license to law, and maybe one has handled many cases and was mistaken in his testimony, because that was not Mr. Horne's testimony. Mr. Horne did not testify that he was there, that he was not the one who did that. He said he didn't tell his lawyer that. So I
Did
understand.
the trial judge accredit the trial counsel? Or did that come up?
I cannot remember whether trial counsel, whether the court accredited
When I say
trial
judge, I meant the
counsels.
post-conviction.
Yeah, whether the post-conviction court specifically accredited Mr. Messler's testimony, though possibly, Your Honor. But in addition to this abandonment issue, trial counsel filed a motion for severance that he never followed through on. He filed a written motion for severance, and then he never actually raised the issue. And the trial judge, not the post-conviction court, the trial judge stated to Mr. Messler when he raised it in the motion for new trial that had Mr. Messler raised the question of severance at the time of, prior to trial, when that would have been the appropriate time to raise the motion, that he would have granted that motion for severance, because Mr. Horne was in a totally different position than the other 3 co-defendants. Mr. Stubbs' testimony was inconsistent during trial. Mr. Stubbs initially said that Mr. Mosley was the shooter, and only after a period of time did he then say that Vino, as he called him, was implicated. And then there comes the failure of investigation. And again, we have an issue where the trial court is saying that there's no prejudice that was shown, because trial counsel admitted that he had not really investigated the case, because his intent was always to present Mr. Horne's testimony in exchange for consideration or for an offer or deal. What could counsel have presented had there been a better investigation? Well, we would have had the testimony of Mr. Horne's mother that was presented at the post-conviction hearing, as well as the testimony of the Youth Services Bureau agent who came and testified and said that Mr. Horne was under an instruction to call in at that time, and that, to her recollection, he had called in on the day in question. Is that perfect evidence of prejudice? Maybe not, but coupled with the question of whether trial counsel abandoned Mr. Horne, and along with that, we have a strong case here, clear and convincing evidence of prejudice to Mr. Horne. The tolling issue. The trial court appropriately decided tolling. The Whitehead case has laid out when courts should toll the statute of limitations. Mr. Horne was a few days shy of his appropriate time to file his post-conviction petition. Mr. Horne was a juvenile at the time, and he relied on the Board of Professional Responsibilities assertions that Mr. Messler was his post-conviction attorney. Had, of course, the board looked up the readily available public information that Mr. Messler was not his post-conviction counsel, that Mr. Messler had represented him on direct representation and therefore could not represent him at post-conviction, the board would not have referred to him that way. So that created further confusion for Mr.
Isn't
Horne.
there proof in the record that the petitioner acknowledged he was aware that trial counsel was not his post-conviction counsel prior to the 1-year running of the statute?
Prior to the 1-year running of the statute, he was aware that he was not receiving representation on post-conviction from Mr. Messler, but he did not understand why Mr. Messler hadn't sent him the file if Mr. Messler wasn't his lawyer. Does that make sense, Your Honor?
A little bit, but did he also receive the transcripts he was asking for before the 1 year? I know there was some testimony that, trial counsel said, hey, it's a big record, it's at my office, your dad can come pick it up. And I think there's some dispute about whether or not petitioner actually received that correspondence, but he did in fact send him the transcript before.
After the board forced him to, yes, Your Honor. Whether that was prior to the deadline of the post-conviction, I think it was right up on it. It might have been within days of the post-conviction deadline.
But doesn't that not support and maybe even there's testimony in the record that petitioner knew what the deadline was? I mean, he knew he had to get all of that for the filing.
I don't think that petitioner knew when his deadline was. I don't think he was clear on that. I don't know that anyone ever gave petitioner a date. Petitioner had jailhouse counsel, and probably what happened there was that jailhouse counsel refused to help petitioner without having the record.
We don't know that.
We don't know that, but we do know that Mr. Horne struggles with literacy. You can see that in his letters to his counsel, and you can see how Mr. Horne might struggle to fill out even the pro se post-conviction form that's generally provided to people incarcerated. But the trial court appropriately considered the factors by which one should determine whether due process tolling is appropriate. That is, that Mr. Horne was somewhat specially positioned because he was a juvenile at the time that the offense occurred, that Mr. Horne didn't have a great education, and that Mr. Horne was led astray by what was said to him from authority by the Board of Professional Responsibility. We would ask that this honorable court reverse the trial court's denial of the petition for post-conviction relief and remand for new trial. Thank you.
Thank you.
Good morning. May it please the court. My name is Kirby May, and I represent the state of Tennessee. We're asking this court to reverse the errant finding of the trial court as to the tolling of the statute of limitations for due process. Simply said, the trial court never made a finding as to the second factor. While the trial court found that Mr. Horne was diligently pursuing his rights, the trial court never found as to the second factor that exigent circumstances created a barrier that caused the defendant to not file timely. In particular, the point that the defense is asserting is that the attorney's misconduct caused that. And under Whitehead, which is a seminal case here, is very narrowly defined as to what can cause due process tolling. There are only 3 due process considerations under Whitehead, and here the defense only alleges attorney misconduct. However, the trial court, and you can see from the transcripts about 72 page, I think it's 72 to about 80, is where it analyzes the testimony in the supplement of the transcript, where the trial court simply finds, and quote, on page 80 it says, the defendant was simply found that the defendant was diligently pursuing his rights, and then goes further at page 82 and merely states, I just believe due process and fundamental fairness requires tolling of the statute. The trial court never, the post-conviction court never addresses the extraordinary circumstances prevented Mr. Horne from timely filing. And it specifically never finds attorney misconduct, and that's required for due process tolling. The post-conviction court never found that trial counsel abandoned him or acted adversely or the defendant by lying to the defendant or misleading the defendant. And it never found the other part of due process tolling is not only that extraordinary circumstances stood in his or her way and prevented timely filing, but also have to show that there's approximate, the causal relationship. This is under Montgomery. Again, it's narrowly defined in Whitehead of what attorney misconduct is, but then also in Montgomery, which is a criminal court of appeals decision here, is narrowly defined as what prevents. And it states that there must be a causal relationship between the extraordinary circumstances and the late filing. And it goes further in Whitehead, it says this is the rarest of circumstances, that the threshold is very high. And then it goes on further in Whitehead, it says, this is very high because lest the exception swallows the rule. At what point? 2 weeks, 1 week, 3 weeks, 4 months? Well, it sounds okay, maybe, but that's not the decision in the Supreme Court held in Whitehead. It's a very high barrier and bar. And then, to avoid the confusion, Volume 2 is the letters provided by the defendant at the post-conviction hearing. They're very telling, each one of these letters, as to what was in the defendant's mind, what he knew, and at what time. And clearly, Mr. Horne, even before the Supreme Court denied permission to appeal, was sending letters both to trial counsel and to the criminal court clerk's office as to seeking his record. And in response to, on January 15th, the Supreme Court's denial of permission to appeal, on February 9th, defense counsel, through his associate, sent a letter to the defendant, which said, the Supreme Court's denied your application to appeal, and further specifically says, since our representation has ended.
But and there's some dispute about whether he received that letter.
We'll get there. One second,
Okay.
Your Honor. Very good question. So, and it says, and on top of it, in this letter on February 9th, it goes on to say, you've already gotten your discovery, you've already been provided your appellate brief, you've already been provided your notice to the Supreme Court, your request to the Supreme Court for permission to appeal. So he had those things to work on. This is not like he didn't have any part of his record. And he indicated, as Your Honor noted, that he had his transcripts and record available at his office for his family to pick up. Is that the best practice? Probably not. But it did note that that was available. And then your very precise question is, did he ever receive that letter with notifying him? On October 13th, 2015, the defendant submitted a request for assistance to the Professional Consumer Assistance Program. And in that document, which is page 14 of Volume 2, he notes, have you requested assistance from complained by this lawyer? And he says, yes. On December 29th of 2014, I wrote Mr. Messler. On December 31st, 2014, I wrote 2 letters to the clerk of court. All 3 letters requesting my transcripts. The next line, have you contacted your lawyer named above on the issue of this request? And he says yes. It check marks yes. And in his writings, he writes, sometime in February, I received a letter from Mr. Messler stating he can no longer represent me. That's the letter in question. And you remember, you also had, Your Honor, you discussed the credibility findings. While the judge here at the post-conviction court did not find a credibility finding, this is clearly indicating he testified, Mr. Horne testified at the hearing, he never received this letter. But his letter to the board says he did. And it goes further. In that same time period, in September 16, 2015, on page 11, he says, Mr. Messler has failed to give me any type of assistance regarding my case in post-conviction. And he goes on, he says, but he told me he refused to go any further in my case, again referencing to the February 9th letter. And he says that multiple times. Also, on that motion notice to the Board of Professional Responsibility, page 15 in the volume, I'm behind on my post-conviction due to lack of paperwork. And he goes on to say the transcripts, a copy, and he mentions a copy of my brief and motion of a discovery is what he has. And he goes on further on October 8, 2015, I have no attorney to assist me with my case, clearly indicating he knows Mr. Messler is not representing him. And he goes further, he says, before he withdrew from my case, again indicating he knew Mr. Messler is not representing him post-conviction. And he says, he sent me a letter stating that he can no longer take my case. Again, that's the February 2015 letter. So all the way as far back as October, when he's asserting to the Board of Professional Responsibility that he has no assistance, he knows he's not represented by Mr. Messler. He's just seeking his transcripts.
Is there anything in the record definitively showing that he knew when the statute ran?
No, there's a lot of conversation. That Mr. Horne stated at the hearing that he was confused as to the actual deadline of the statute of limitations. In his letters, even up to his letter to the clerk of court in December of 2015, asking about when the date is. And in response to in November 5th letter in 2015, Mr. Horne does indicate he received the transcripts. So there's the October 20th letter from the Board of Professional Responsibility asking Mr. Messler to follow up with the transcripts, and clearly between October 20th and November 5th, he's received the transcripts. And Mr. Messler did testify that as soon as he got that letter from the board, that he did send the transcripts to the defendant.
Is there anything in the record that definitively shows the petitioner knew when the Rule 11 was denied?
In that letter from, the letter from Mr. Messler on February 9th had attached a copy of the denial. And to go further, what Your Honor very poignantly noted is what he knew and when he knew it. And now, one second. One thing this court has made clear in its decisions regarding the tolling statute of limitations being in the rarest of circumstances, this court in Montgomery, Weidkamp, Carino, and Davis, which are all cited in the state's brief, have all indicated having the file, the record, is not required for a filing petition. And in this case, as Your Honor noted, in Johnson was a case this Supreme Court Appeals handled that found that 2 months was sufficient time. In this case, the defendant, if you look at the record, at worst, if he received his transcripts on November 5th, which likely he received it before then, he had 71 days with the record. And there's nothing in the record indicating that anything by Mr. Messler prevented him from filing his bare bones petition for post-conviction past November 5th. That's over 71 days prior to the statute of limitations running. And then also in Watts, the Criminal Court of Appeals noted that the ignorance of procedures, even when alleged to stem from an attorney's negligence, was there's no indication of negligence upon finding by the post-conviction court. The failure to render advice as to the timing is not for tolling. And in Montgomery, the petitioner's lack of understanding of the post-conviction procedures alone is not an extraordinary circumstance. And also, there's an indication that as in Watts, the petitioner had access to the law library at the jail and advisors. So while is it a perfect system? No. But there's nothing showing that Mr. Messler did anything that would rise to the level of misconduct. He didn't abandon him. He followed the procedures. Maybe he was too kind, because that was one thing the post-conviction court noted was, well, you said in your letter, if you have questions, ask. But there's nothing showing that there was continuation of attorney contact regarding that from Mr. Messler. And there's nothing showing that he had it was direct and adversely impacting by lying or misleading. So Mr. Horne clearly did not meet the standard as required by Whitehead. And thus, tolling is inappropriate in this instance, and this court should reverse as to the statute of limitations finding due process and should dismiss the petition. However, if this court goes on and finds that tolling was appropriate, then we look at the trial or the post-conviction court's findings, and this office believes that this court should find that those findings were appropriate and that the defendant simply did not show that he was prejudiced as to the attorney's any deficiency or prejudice as to his role as an attorney. In this instance, there were three things. One is the proffer. And there is an issue with deficiency as to permitting his client to meet. However, it never got to that point. If you look at the record, Mr. Messler had met with the defendant on multiple occasions, and this dovetails into the investigation as to the alibi aspect. He had met with him multiple times, and there was clear testimony, even from the petitioner, that he had been that Mr. Messler met with him multiple times and went line by line, that was an exact quote from Mr. Messler, through his statement, and compared it to the discovery with Mr. Horne, and compared it with what he had learned from other defense counsels on this case as to what would happen. And during those meetings with Mr. Horne, he found it was consistent with the evidence that at that time, the belief that Mr. Horne was a low-level person involved in the case, but was not the shooter. And so Mr. Messler sought to seek cooperation and benefiting his client. Again, it's an adversarial role, but you're looking out for your client's best interest. And so that was the role that they had discussed, and that was clear that they
So you're arguing that was adequate investigation?
Between reviewing the discovery, meeting with his client multiple times, and he also testified he met with the other defense counsels and reviewed the evidence from their perspective. And at that point, that was his position. And yes, that's a position to state that it was adequate. Now, again, we get to allowing the proffer, that was deficient. However, the prejudice, that's the second prong of this, and the defense has to meet both of them, and by clear and convincing evidence. And here, the defendant testified repeatedly, and it's noted in the state's brief, how many times he said that he had made that decision, had not informed Mr. Messler, but had made that decision that he was not going to cooperate, did not want a deal, and was not going to meet with the prosecutors. But again, he had not informed Mr. Messler of this. And so the post-conviction court found that was significant, that nothing would change, because the only thing that came out of the situation at the proffer session was that he was not going to be a cooperating witness. But the defendant had already made the decision he was not going to be a cooperating witness. He had made that decision. He was abundantly clear at the post-conviction hearing that he had made that decision and he was not going to cooperate even before what happened. And again, you also look at the actual language that was used during that meeting between Mr. Stubbs through the walls. It was, hey, from Mr. Stubbs, it was, hey, cuz, we got to tell him the truth. And the response from Mr. Horne was, no way, Hug, no way. That's basically it. That was what was presented from that interaction. And then it goes on further that the trial court found that the outcome would not have been different. If he had already made that decision, he was not going to cooperate, the outcome of the trial was not going to be different.
What about we've heard about conflicting proof about whether somebody did talk with him or not?
So
What's
the
your
only
position on that?
person, the only conflict was that the detectives was very clear, Joe Stark, was very clear that Ray Lapone, the prosecutor in the case, was not present. That when this conversation occurred, a phone call was made by Detective Sergeant Stark at the time to Mr. Lapone, who hadn't even arrived either. Neither had the other attorney from Mr. Stubbs, and that was clear from the record. And that he told him what he had just overheard. Sergeant Stark was clear, while did not give great detail, but was clear that Mr. Lapone did not meet with Mr. Horne. But Your Honor can look at the record as to that. And that, but Mr. Horne did testify that the prosecutors came in there and questioned me for 20 to 30 minutes, and I wasn't cooperating. Again, it goes, while the court did not make a credibility finding, if you look at the other things in the record, it looks like it was sort of a self-interest argument. And so then the next, as to the alibi and the failure to investigate. Well, the funny thing about that is, again, according to Mr. Messler, he was never notified of the defense interest in alibi. Now, also having to go back. When he was initially interviewed by law enforcement with his uncle present, he said he was on the scene. And then after the proffer went the wrong way, Mr. Messler met with him, and Mr. Horne laid out the exact way the situation, the homicide went down. In particular about the gang relationship, it was a gang hit, and that what his role was as shooter. And he put himself on not only on the scene, but as himself as the shooter. So, and then when at the post-conviction hearing, which sometimes post-conviction attorneys fail to put on what should be the alibi thing. So gratefully, the defense did that in this instance. He put on the defendant's, the mother who testified that she couldn't even relay an alibi defense because she was not at the house at the time. And then in addition, they put on the defendant's father, who, when he testified, said, yes, the defendant said I was on the scene. So he's not alibi to witness. And then they put on the probation officer, which, even if Mr. Messler had known about it, might not, this is speculation, put that person on because you're saying your client's under house arrest. So that goes to an issue there. But she testified that he wasn't on her GPS. He was on her. He had to make a phone call at 6:40 or 6:30, 6:45.
And he didn't do that.
She testified a phone call message was received at 6:45 indicating that was Mr. Horne, but there was no ability to verify that from phone number or that was his voice. And there's no other information. The homicide didn't occur until 10 or so o'clock at night, that he was home. He could have been home and made that call and still been at the homicide. So that probation officer still not an alibi defense. So you look at it, there's simply not an alibi defense here. And that's what the post-conviction court found, that the performance as to the investigation and handling of it was not deficient, that trial counsel were prepared for trial, and the witnesses could not provide an alibi. And the trial counsel had a strategy for handling the defendant's role, and that rolls into the severance issue. Very briefly, because I have a minute. As to severance, the preference under Rule 8 and under Rule 14 is for joinder in this instance. Because of the nature, it's a single incident, multiple defendants with related evidence against all, and that the defense simply did not meet the standard for a Rule 14 severance. It just simply did not. And that Mr. Messler had a tactical way of handling it. While he did file a motion to sever, he never pursued it. And his decision was more of the evidence was against the other defendants, and that he was going to proceed showing, again, the defense never presented, except for Mr. Stubbs, that he was the shooter. So his position was he was to impeach Mr. Stubbs as trying to get a deal, and that all the other evidence connected the other two defendants, McLean and, my time is up. We'd ask for your honors to reverse the trial court's finding as to the statute of limitations tolling, and if you do not, we ask you to affirm the post-conviction court's decisions as to the conduct of the trial attorney. Thank you so much.
Thank you, General Matt. Ms. Holland?
Quickly on the tolling issue. The trial court did find that there were extraordinary circumstances. That's in Volume 1, page 45, and that would be a factual determination by the trial court, to which this appellate court would generally give deference to those factual findings. Mr. Horne did receive, as Judge Ayers asked, Mr. Horne did note that in November 5th, 2015, he had received the transcripts. He had written the board on September 29th, 2015. Well, that's when he received a response from the board, where the board says to him, "We assume you mean that Mr. Messler was the attorney for your post-conviction." So that is understandably a moment that creates some confusion for Mr. Horne, because now he's hearing from a place of authority that Mr. Messler is his post-conviction lawyer. So this is not so much about attorney misconduct as it is about counsel not communicating with his client, not telling him when his deadline is supposed to be. The notice that Mr. May makes reference to, where petitioner allegedly admits he received the letter in February, it's not super clear. It's a form that he's filling out to the board. He says sometime Feb. It looks like it might be Feb. It doesn't say sometime in February. It says sometime, maybe it's September, or
He does acknowledge in that.
he not acknowledges that Mr. Messler says he can no longer take my case, were his words. So it's not clear that he understands that Mr. Messler is not representing him in the post-conviction, and then he receives that confusing message from the board. "We assume you mean that Mr. Messler was the attorney for your post-conviction." That we have an extraordinary circumstance here because he's receiving mixed messages. He's receiving mixed messages from his attorney, contact me anytime if you need me, and he's receiving confusing messages from the board. So due process tolling was appropriate here. And as we turn to the merits of the petition for post-conviction relief, Mr. Horne was prejudiced by his counsel not accompanying him to the homicide office. Mr. Horne never would have made statements to Mr. Stubbs had Mr. Messler been with him. Mr. Horne never would have gone to the homicide offices if Mr. Messler had simply said to those prosecutors who he trusted, listen, I'm uncomfortable with you speaking with my client without me. That could put him in a compromising position, and I don't know what could happen without him being in my presence. Please don't transport him. And trial counsel failed to do that. This court should affirm the trial court or the post-conviction court's due process tolling and should reverse the petition for post-conviction relief and grant relief to Mr. Horne and award him a new trial. Thank you.
Thank you, Ms. Holland. All right, anything else this morning, Madam Clerk? All right, we'll be in recess then until the afternoon docket.
All right.